back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me today is Sam Kill, Senior Associate from MBK CHAPMAN. How are you doing today, Sam?
Doing well. Thanks for having me, Mike.
Well, as you can see, we have new microphones, new equipment, like we said we would. Mm-hmm. So let's hope that this stuff works better.
Yeah.
And we've got a new thingamabob right here as well. So today, Sam, we are going to talk about, I say, one of the top 2 or 3 most common complaints that we hear from homeowners who live in HOAs with a bad HOA board. Mm-hmm. And that is something called selective enforcement. And today we're going to talk about what selective enforcement is. We're going to talk about what the law says about it, why it's illegal. Mm-hmm. And most importantly, I'm going to give you some tips and tricks that you can use that work to build leverage on your side and flip the script on a bad HOA. Okay? So let's start right at the beginning, and I'm just going to have Sam help us out by defining some terms. So Sam, at its most basic, what is selective enforcement?
Well, Mike, selective enforcement occurs when a board applies HOA rules and standards inconsistently. And in other words, it's applied unevenly. The rule itself is not the issue, it's how it's applied.
Okay, what does that mean?
Meaning, let's say you and a fellow member, a neighbor of yours, are being treated unevenly for the same exact thing.
Okay.
You're being cited for a violation, your neighbor's not, for the same exact issue.
Okay. All right. Well, and on its surface, maybe it's true, but on its surface, it could scream favoritism, right? Mm-hmm. Or politics, or even personal grudges. Mm-hmm. You know, we've done podcasts where we talk about, a lot of people that serve on boards have egos, and you get all that sort of thing, personal grudges and retaliation. Yeah. Let's say you're calling them out for doing something wrong, and and then a week later your architectural plans come up, or somebody sees your dog off leash for a sec, and instead of sending a warning letter, suddenly you got a hearing letter because you're going to be fined. It's like everybody else gets a warning, but not you. Right. That's what you're talking about.
That's exactly it. But okay. These rules have to be applied consistently, fairly, and in good faith.
Right.
Yeah.
So it is often a result of ego. It is often a result of personal grudges. It is often, but it's more than that, right? It's sometimes, if you know how to do it, it's an actual legal vulnerability on the part of the HOA that you can flip the script on and use it for leverage.
Absolutely.
That's what we're going to talk about today. So let's be clear about something. California law, and we'll talk about why in a minute, California law does not allow HOAs to enforce their governing documents in an unfair or uneven way. So Sam defined selective enforcement as treating you differently than they treat somebody else that lives in the community for the same thing. That's not allowed. You can't do that, okay? And rules, whatever they are, whether they're affirmative rules, you have to have your dog on a leash, you have to have your trash cans, brought in by a certain time, or you can't have, this kind of structure, or you can't have this on your house.
Restrictions, yeah.
Yeah. Those are all rules, okay? And if you have 2 people with requesting or have done something similar, then the results should be the same.
Exactly.
Okay? And if they're not, you're dealing with selective enforcement.
Right.
So when boards, and they do this, they cross that line sometimes, you can absolutely fight back, and you can render whatever punishments or fines have been asserted against you, you can render those moot. Okay,
100%.
So this is important, okay? So today we're going to discuss all the aspects of selective enforcement, okay? And we're going to teach you how you can fight against it, how you can turn, into leverage and solve the issue, okay?
Yeah.
So Sam, you've given us a good definition, okay? Let's start with a few examples. Let me give a couple of examples, and then you take some, because you see these every day, because it's, like I said, the top 2 or 3 most common things we see. So you got a neighbor that's ordered to remove, or you're being ordered to remove certain hedges or plants that you've planted in your thing.
Sure.
And you look across the street or down the block or on the next block over, and they have the exact same hedges that you're trying to put up, or that you have up, and they're saying take them down.
Right.
Same stuff, and they let those people slide, not you.
Yeah.
Or you paint, you have let's say a pony wall on your balcony, and you paint it a certain color, and they say, no, that's not one of the established colors, repaint. And you look around and that same color's other places, or different colors, but colors that aren't on the approved palette are being allowed. So let's say yours was, on the brown side, somebody else might have a purple or red or green. Why are those allowed if they're not in the permitted palette, right?
Right.
Or you receive a violation for not taking your trash cans in by a certain time, and yet your neighbors routinely let them stay out, till the next day, and they've never been fined.
Right.
They've never even gotten a warning.
Yeah.
That's all selective enforcement, right?
Or you get...
Give me some more.
You get a violation notice and fines associated with parking in your driveway, and your neighbor and other members within the community doing the exact same thing, and it's not happening to them.
Yeah, because you're not, let's say you're supposed to be in the garage, and you're not.
Exactly.
Right.
Let's say you're repainting the fascia or exterior of your home a certain color scheme, and someone else has a relatively comparable color scheme. You're being fined and penalized for it.
Right.
They're not.
So you drive around the neighborhood, you look and you go, oh, I like that color. I'm going to do that too. So you submit your plans, and then you get a no.
Right.
Right? That's what we're talking about. And then you submit a picture and say, wait a minute, look, this house and this house and this house, they have that color. And that's I saw it on their house. That's how I got the idea. And your HOA goes, nope, it's not allowed.
Happens all the time.
You can't do that.
Nope.
Right?
Can't.
Okay. What about you're fined for putting up a basketball hoop? This happened in a case that we had. This was one of the issues, by the way. This wasn't the major issue in his case, but this was one of the issues, and we did address it because it was there. But he got fined for having a basketball hoop, one of those portable ones, not the ones that are fixed to the house.
Right.
That you have the water in it.
The mobile ones. Yeah.
Okay.
Yeah.
He had the basketball hoop. Instead of rolling it in every night, they just kept it out of the way, but they kept it outside every day. He got a hearing letter. He had to appear at a hearing and was fined $100. And there are like 6 or 7 other houses in the neighborhood, including one of the board members, who have the exact same or similar basketball hoop up, and they've never been fined, and they've certainly never been told to take them down.
That's unbelievable.
That's classic.
And it's a very obvious, conspicuous item. You can't even plead ignorance.
Right.
You see it. It's right there.
How about when an HOA, there's complaints about an annoying barking dog in the vicinity of your house, and they say, hey, you're causing a nuisance. You're like, wait a minute, my dog's never outside. The only time my dog is ever outside is when I let him out for 5 minutes to go potty.
Right.
And then they come back in, and then I take them on walks, but they never spend time outside. They are in-house dogs. They're always with us. It's not our dogs. It's not possible.
Right.
And yet you have dogs down the canyon. You can hear other dogs. They're barking all the time. They're outside while the people are at work.
Selective, you're being targeted.
Exactly.
Yeah.
Okay.
Well, another one is when boards restrict your amenities access, for instance, the pool or the gym or some other amenity.
As a penalty, right?
As a penalty for an alleged violation when someone else who's engaged in the same so-called violation is not being deprived of access.
Right. They might pay, I don't know, they just might get a small fine.
Yeah.
But they can still use, in the middle of the summer, they can still use the pool, but no, they jumped right to.
Right.
Yeah.
Yeah, more egregiously applied to you.
Exactly.
Yeah.
Okay. So those are all examples we've seen. Those are all from cases that we've had. Okay.
Right.
Selective enforcement, it doesn't always have to look dramatic at first glance. Sometimes it's obvious. Like the examples we gave, those are obvious ones.
Yeah.
And they're very easy to spot. And that's why they're so easy to talk about. And that's why some of you listening are probably can recount either examples just like those or other ones that are very similar. Okay, those are the obvious ones. But sometimes these show up in less obvious ways, a little more subtle, in some day-to-day situations where the difference isn't the rule itself,
Right.
but how the board is applying the rule.
Exactly.
It's not an attack on the rule; it's an attack on its application. Right.
Exactly.
So let's talk about why is selective enforcement illegal in California. Sam, I'm going to let you take the lead on this. Why is it against the law?
Yeah, well, in short, it really goes to the core principle and tenets of, fair play, due process. Really, that's what it comes down to.
Public policies.
And public policy. So California law and the Davis-Sterling Act have captured this principle or these tenets and prohibit selective enforcement for those exact reasons. And Specifically, Civil Code Section 4350.
Part of the Davis-Sterling Act.
Correct. That's implemented to HOAs and applies to HOAs. Requires that rules be enforced and applied fairly, consistently, and in good faith.
Right, and
reasonably.
Right, and we have cited in multiple episodes of this podcast, we have cited Civil Code 4350.
Yeah. It's
the one where rules have to be reasonable. They have to be passed in a proper fashion. It's the one that sets out the nature of the rules that HOAs are allowed to pass. But one of the requirements, in addition to being reasonable, is, you just said it,
good faith and consistent.
Good faith and consistent, which implies Yeah, it doesn't say they must be, selective enforcement is bad. It doesn't have to say that. It says they have to be consistently applied.
Right.
Exactly. And that's exactly what we're talking about here, right?
It's a bit of a guardrail against transgressions and essentially favoritism and things of that nature.
Of course, because there's nothing more fundamentally unfair than do as I say, not as I do. Okay? And there's nothing that violates somebody's due process rights more than punishing one person and then not punishing somebody else for doing the same thing.
Exactly.
Because then due process is just a joke.
Right.
Yeah, they go through the motions. Yeah, we sent you a notice of hearing. We heard you. We heard your defense. We voted and we decided that we're gonna fine you. You got your due process. No, I didn't, because I gave you evidence that Bob and John and Phil and Ralph have all done exactly the same thing, and you haven't even given them a phone call.
Right.
You know, never mind, call them in for a hearing.
And that uneven application of power also leads to mistrust. I mean, you lose trust and confidence in the system or the community here.
And then it's like, what the hell? Why should I do any of this?
Exactly.
Okay. So, in other words, I think you eloquently stated it, that it's illegal in simple terms because it undermines uniform rule of enforcement. It produces, and I want to use two words that are not from 4350 though, okay? It produces, people who've listened to his podcast, especially the one that we did on architectural guidelines, are going to remember our use of the terms arbitrary and capricious. Okay? Now, that is under Civil Code 4765, which is the architectural guideline statute in the Davis-Sterling Act, where it talks about arbitrariness and capriciousness. But courts have actually said, you know what? We're going to expand those rules, arbitrary, capricious. Yes, it's in 4765 relating to architecture, but we're going to apply it to HOA enforcement in general.
Yeah.
Courts have expanded that and say, you know what? Those are fundamental parts of what is reasonable, what is consistent. You can't be arbitrary in how you apply the law, because if you're being arbitrary or capricious in your application or enforcement, you are doing exactly what 4350 says you can't do.
It propagates inconsistency.
That's right.
Yeah.
So the fundamental concepts of, as you put it, fairness and due process require that that the rules are not only reasonable and applied consistently, but that they're not applied arbitrarily and capriciously. When we used it before, we talked about rules can't be arbitrary and capricious.
That's right.
That's true. But their application also can't be arbitrary and capricious.
That's right.
And courts have agreed with that interpretation. So we love those words.
We do.
Sam, can you refresh my recollection or the listener's recollection as to what the difference between arbitrary and capricious are? Because they're very close, and sometimes the same thing might actually butt against both of them. But there is a difference. So tell me what the difference is.
Well, that's exactly right. At their core, I mean, the words capture the same core idea, as you said.
Right.
So, I mean, in basic English, arbitrary means decisions based on personal whim or favoritism rather than facts, while capricious is decisions that are unpredictable and inconsistent.
Right.
I mean, that's what it comes down to.
And in its application, if a board is arbitrary, we're going to enforce against you because we're just in a mood right now to be more strict.
Yeah.
We've been merciful in the summer, but now it's winter. We want to be, that's arbitrary.
That's right.
Okay.
Yeah.
Or capriciously is, we've let you get away with this in the past, but we're not going to let you get away with it anymore. But we're going to let him get away with it anytime he wants. That's more capricious. Right. Can't do it. Okay. Yeah. So HOAs, I think it's clear to say HOAs have weaponized some. Now we're going to go back. Remember at the beginning, we talked about how sometimes it is ego. Sometimes it is retaliatory. Right. Sometimes it is, they just don't like you. Yeah. Okay, you speak too much. You make us look bad. Whatever it is, you question us in open meetings. Sometimes it is that. And so in a bad HOA, if you get a particularly obnoxious group of board members, they might try to weaponize enforcement of the rules against you, because there's nothing more in your face than saying, I have the power to make you give us money. Okay, people don't want to pay more than they're supposed to pay.
Yeah.
And when you get fined, it's not necessarily the amount of money that's the issue; it's the principle.
Especially troubling when it happens to where you live. This is the place where you live,
and
you and your family live.
There's no end in sight.
Exactly. Yeah.
So let's walk me through that weaponization issue. Okay.
Certainly. So in short, selective enforcement is really an accident, right? It's not some random
It's not good. It's not good faith
occurrence.
Oh shoot, we forgot to enforce against other people.
It's really some form of deliberate action, right? Or in some cases, inaction, depending on how from what vantage point you're viewing or interpreting this selective enforcement.
So it's intentional.
So it's intentional. They deliberately weaponize the various tools and resources of the board, oftentimes applying restrictions unevenly. And really the motivations are simple and timeless, right? I mean, we're talking about power, ego, retaliation in the uneven and inconsistent application. And to use those words that we used, unreasonably, in bad faith, arbitrarily, capriciously, these are the ways, those gray areas that a lot of these bad boards navigate to deploy these by way of weaponizing these tools. And
right,
resources.
because sometimes, and I think you're implying this, sometimes the line between selective enforcement and not is very thin.
It is. It can be.
There's a room, in other words, there is a gray area where you can where it can be obvious that you've selectively enforced, but there be an explanation.
Right.
And so it's not necessarily enough to be legally actionable. And bad HOA boards, especially crafty board members who are trying to weaponize this, will bathe in those gray areas. Okay?
Yeah.
Because they think, and this is when they meet us, they find out they're wrong. They think they're safe there.
Yeah.
Okay? And it is, arguably, it is harder if they're strictly within the gray area. When they do the obvious, then it's obvious. I'm going to give you guys an example later of something that was in the obvious, but we were dealing with obnoxiously clueless board members who had egos, but they weren't vindictive. Okay?
Yeah.
But the vindictive ones,
yeah,
they operate more in the gray.
And that's where the personality ego parts are really profound in terms of how they take over, and then it becomes a bit of a personal vendetta, so to speak, right? And one person, one group of homeowners are targeted disproportionately.
Right.
And it's very blatant, too.
Right. Exactly. So, obviously, you can't let that stand, okay?
No.
So, you have to, when you are facing selective enforcement, and the bigger the ticket item, the more important it is to face it. So, if you're talking about a one-time fine of $25 because you left the trash cans out past 7 o'clock, it might not be worth fighting. If you did it, if you did it, and you know that they're not nailing other people in the neighborhood for the same thing, but it's only happened once, you pay the fine and maybe you move on, okay? Or, and then maybe you act if they start nailing you every week, right? You're always 20 minutes late and they nail you every week and you know they're not doing it, then maybe you act. But if it's something like an architectural plan where you're trying to put up you're trying to paint something, you want to change the look of your house, other people have, or you're trying to put up a fence and other people have that fence. It's something that's going to affect the quality of your life in your mind, the beauty of your home, whatever it is, and you're being prevented. Then that's when one time is too many and you got to fight. So how do you do that? Well, let's start with that, okay? The first thing you do is you want to gather proof, right?
Yeah.
The suspicion alone is never going to be enough. No court wants to see that. You're not going to get any action. You're not going to get anywhere legally if you can't provide proof, okay? So if you suspect or believe that you've been, they are practicing selective enforcement against you,
right,
you got to gather some evidence and some proof, okay? So, and that's the only way to be successful. You have to be able to show, other than just, well, because I know it's true, you have to be able to show that you're being treated differently, okay? Right. So the first step I will call is comparisons, okay? What does that mean? Well, look around your neighborhood. You want to paint you used a fascia. You want to paint your fascia a different color than it currently is. And it's not necessarily a color that's on the accepted palette. And if your HOA has an accepted palette, and many do, it's not necessarily there, but it's still very good taste. It's not outlandish. More importantly, you can point to 5, 6 other houses or more in the neighborhood that have the exact same color. Okay? So you go around and you look, you go, well, that's the same color I want, and that's the color I want, and that's the color I want. And they're not letting me do it. But these people have them, and it's out in the open. It's right there. Anybody could see it. And so look around and compare yourself to every other neighbor or fellow HOA member who has whatever issue is at issue with you, and then photograph it. Now, there's different ways to do this, okay? So, again, I'm going to give you guys an example in a case study. In a few minutes, I'm going to go through a case that I handled personally It was somebody close to me, and I handled this case personally for them as opposed to giving it to one of you like Sam or everybody else. I took care of it. And I'm going to go into the details, just not going to give any names, obviously, for privilege purposes. But I used a drone, okay? Mm-hmm. Now, some HOAs have rules against flying drones within the confines of the community. And so you always got to be careful about that. You might still do it, but you could be subject to discipline for that. And it might be worth it, okay? Especially with AB 130, $100 fine. It might be fine. I'll take the $100 fine for having my drone footage. But you also have to be careful about privacy rights, okay?
That's right.
When we did the drone, and I hired somebody to do it, when we did the drone, they were told, do not take video of any property where somebody is outside in there. Like if we're taking video of their yard, do not take a video. Go elsewhere if somebody's out in the yard. Only if their yard was empty. And another thing we didn't do is I didn't have the guy like come down real. Everything was done from at least 200 feet up, but don't come down low. Don't direct the drone into private areas. Just very careful about the privacy rights thing because there are some powerful protections under California law for people's privacy where they have an expectation of privacy, and a yard is included. So if your HOA doesn't ban drones, you still got to worry about privacy. If they do ban drones, you might still do it anyway. Point is, or walk around the neighborhood. Now, if it's with a camera and take pictures. Now, if it's something that's in the front, like fascia, or it's plants in the front, you don't need a drone. Just go and take pictures. But if it's something that's in the backyards, then that's when a drone comes in handy. Or if you have a gate, a see-through gate with slats, right? They aren't walls. And you could go into a common area and take pictures into their yard through the gate, you could do that too. But in the particular case that I'm going to go into details later, a drone was the only way to get this footage, okay? Mm-hmm. But I was very mindful about honoring privacy rights, okay? So you want to go and do a comparison, right? Next, you want to add records. You want to do a records request. Sam, what's the code section for the records requests? Just give me the code section and nothing else.
5200, Civil Code section.
That sounds familiar. Have we talked about that?
Numerous times.
Yeah. In many of our episodes, we have podcasts. Not only do we talk about it at length in a long episode, we actually have a short on 5200 as well. And it's right in the title, so it'd be easy to find. And I've got at least one article at mbkchapman.com under our library tab. Just go to articles and you'll see one. And there might even be a fact sheet that just gives you the bullet points.
Oh, yeah.
Okay? So there's multiple places through our podcast or our website that you can find all you need to know about 5200. Okay? You want to do a 5200 demand and you want to get committee notes. Remember, anytime a board meets, whether it's an open meeting, executive session, or in committee, even if they're not all members of the board, it's still considered a meeting. There has to be minutes. Now, homeowners are not entitled to executive session meeting minutes, but they are entitled to committee meeting minutes, and they're entitled to open meeting minutes. So see if you can get, if your HOA has an architectural committee, get the minutes. Okay? Find out if other people have been denied. For you see somebody that has whatever fascia you want, the color will stick with the paint. We see somebody with that. Find out if they painted with, if they did an application. If they painted without one, that's even worse that they're getting away with it.
Yeah.
That's even worse. That's even more selective.
Right.
Okay? So I assume that they got permission. It's still selective enforcement, but get your evidence. There's your 5200 demand. And then we're going to do something that I call layering. Okay? And that is, if there's a due process issue with you, did they send you the letter for your hearing with the proper amount of time before? Did they give you at least 10 days notice? Did they tell you the nature of your wrong? And at the hearing, were you afforded an opportunity to provide a defense? Okay? These are all due process issues. And if any of those are denied, you can layer your 5200 demand. So now you have documentary evidence. You've got photographs or video footage from a drone or photos from a drone. And you layer those two kinds of evidence onto the due process violations, and you start stacking those.
Oh, yeah.
Okay?
And in the aggregate, that can be really powerful.
Yes.
I mean, that's the way to do it.
You build your response, and you reinforce each piece of evidence with different types of evidence if it's available. Yeah. I call that layering.
I like it. Yeah.
And when you stack your layered elements together, you get a much more powerful leverage point against your HOA, because now instead of just one thing.
I mean, you're cross-corroborating by way of,
But more than that, you're pointing out different statutory violations by this one HOA. So let's go into more detail about leveraging, okay? When documented correctly and when layered correctly, you can turn I want my paint this color that nobody else in the neighborhood's really going to care about, okay, into something that other people in the neighborhood are going to care about. It's one thing if you're being targeted. It doesn't affect somebody else. They might not care. They're busy. They have their lives to live. But if the HOA is ignoring due process, if the HOA is violating somebody's right to documents, like the under 5200 demand, people do start to take notice. Your fellow neighbors start to take notice, okay? And the more you can show a pattern of unfair treatment in different arenas of their power, the more powerful your case is going to be. Much more powerful.
Absolutely.
Okay? Because boards know if they press forward, when their wrongs have been pointed out, and they're clearly, the nature of the wrongs are obvious. You gave me 8 days notice for this meeting and you didn't even give me a chance to talk. Due process violations. I asked for these documents and you didn't turn over the committee notes. You said well, that's not directly in 5200, so we're not giving it to you. Well, no, you need to give them to me because they're not executive session, right?
That's right. Yep.
So they've refused to give you documents. If they press forward with those obvious violations, if a homeowner decides to call them on that and won't back down, at some point the HOA is going to have to pay your attorney's fees because they're going to lose. It's that simple.
Yep.
And they know that. So that exposure alone, especially multiple fronts, is often enough to shut them down and make them back down. Okay? So I want to talk to you about, and this is what I promised, I want to talk to you about a case that I had. Okay? This was about a year ago. It's, like I said, it was somebody that I personally know. It's why I handled it. And let me give you some of the facts, okay? My client lives in a community in San Diego County. The homes in that neighborhood start at $3 million and go up to $7 or $8 million. Okay, there are about 200 homes in this community in two different gated sections. So there's compass cardinal points. So let's say one was called north and one was called south. Okay, and he was doing a major renovation to his entire backyard, all new landscaping. He was putting up an ADU. He was putting all new plants. He was redoing his entire pool. It was adding fireplace, so there was gas lines involved, gas fireplace, all that stuff. Barbecue, everything, the whole yard. It was at least a $500,000 renovation, okay? He submitted plans like he should. There were some improvements that they suggested. He did all the stuff he's supposed to do. But and it got approved, okay? So he started construction. And while he had his contractor there, he decided, I want to build a greenhouse for my wife because his wife is into very, very green thumb into planting, has thousands of succulents and other kinds of plants, and she's very good with them. So he said, we've got some space over here. And so he just did a change order with his plans and added a greenhouse. Now, this isn't a greenhouse you buy online and it's a kit you put together and it's boom, bam, thank you, ma'am. No. This was cement footing, cement foundation, permanent structure greenhouse. Beautiful greenhouse, okay? Did not ask for permission. That was not part of the plans. That's a violation. And more importantly, he built it right in the middle of a prohibited setback. So his HOA had front and back setbacks and side setbacks, meaning from your property line, but you can't build anything a certain amount of feet away from the property line. And in the case of the setbacks on the sides, it was 10 feet. It was built at 7 feet. Okay? It's right in the middle of the setback.
Yeah.
Complete violation of his governing documents. Okay? Builds this beautiful greenhouse. It's gorgeous. Okay? The president of the HOA, a lady who does not like my client at all. They've had clashes because my client doesn't suffer dumb people very easily. And this president of the board, was just a dumb person. And my client used to call this president out all the time. So she had it in for our client. Okay? Ego, personality clash. You got two classics. So this president of the board was one of the board members that was doing the inspection toward the end of construction. They have a right under their CC&Rs to go on the property and look to make sure. They saw the greenhouse. They said, well, that wasn't on the plans, and it wasn't. And he got a letter from the HOA saying, take it down. My client said, no. Okay. Then he got a hearing notice, and he went to the hearing. What defense was he going to put? He's wrong. They fined him. He refused. So the lawyer for the HOA, the law firm, writes a letter on behalf of the HOA, and this was a formal ADR demand under the Davis-Sterling Act, basically saying, take it down. In the event you don't, consider this our demand for ADR, because they were going to sue him for probably injunctive relief, okay, and breach of CC&Rs and whatever else they came up with. But that was that, okay? So formal ADR demand, that at that point, our client lawyered up, hired us, okay? We looked at the letter. Well, yeah, of course, we're going to accept ADR. In fact, we not only did we accept ADR, we did a cross ADR demand of our own. And here's what I did before I wrote my response. I sent a quick response to the lawyer who I've had lots of interactions with in the past. We knew this law firm. It's one of the big ones we've talked about that represents HOAs throughout the state. Very familiar with us. We're very familiar with them. I wrote a letter saying, hey, we've been retained by this person. I'm going to give you a substantive response. We accept ADR. Okay. Let's work on picking somebody, but I'm going to send you a substantive response and our own ADR demand shortly. So give me several days. And then I went and I hired an individual who does this a lot for us and took drone footage and probably collected about 400 or 500 pictures of every backyard, every front yard, every side yard in both the A side and the B side of the community. Okay, or the north and the south side of this HOA. And to my maybe not too much surprise, 95% of the homes in this multi-million dollar community had permanent structures within the setbacks. Okay, pergolas, barbecues, fire pits, lots of stuff. Okay, nice. I got pictures of all of it. Now, it's even better than that, okay? Not only in this client's case, the setback issue was one of the issues. The other issue that they tried to nail him on was that it constituted a shed. And sheds are prohibited in the CC&Rs and in the architectural guidelines for this HOA. It's not a shed. I went and got multiple definitions of what constitutes a shed and was able to show it ain't a shed. Is it in the setback? Yes. We'll talk about that in a second. But anyway, I got all this drone footage, still pics and video. And I crafted a very long letter, probably 15-page letter, okay? And in that 15-page letter, I went through, I picked the top, I thought would be the 10 examples of the, remember I said 95%. 10 examples. I picked 10 other homes, including the president of the HOA herself, the one who initiated this entire, and you're smiling because you remember this letter, initiated the entire thing. Her pergola was within a setback. Her barbecue and fire pit were within a setback, which also violated fire regulations, by the way. Anyway, I put together the top 10, and I started the letter by saying, I've received your letter. My client is absolutely guilty of building this greenhouse within the setback. Absolutely in violation. We acknowledge that from the start. It's not a shed, and I explained why, and I spent a page and a half explaining why it wasn't a shed. And on the phone, when I talked to this lawyer, the lawyer conceded it wasn't a shed. But he put in the letter anyway. But he conceded, yeah, it's not. You're probably right. I said, no, I know I'm right. Okay? Anyways, I submitted multiple pictures from different angles, okay, from the drone, of all of these violations, including 2 members of the board, including that president, okay? And I said, so here's the deal. My client absolutely violated. You're well within your legal rights to force him to take this down, and if you went to court with this, we wouldn't win. Not on that grounds. However, you are also guilty of a gross degree of selective enforcement. So here's what's going to happen. Either grant my client a variance, and we're willing to be reasonable in terms of granting that variance, either grant my client a variance or enforce these same rules on every other homeowner in this community, including the president, which would have forced multi-millions of dollars. If you just add up the construction costs for all the torn out pergolas, permanent barbecues, fire pits that would have all had to have been ripped out and redone, and all the sets of plans that would have had to go in. This HOA requires a 20% deposit for management deposit. So all that money, it would have cost in the aggregate, I would say a few $1 million.
Not to mention legal disputes.
Oh, multiple legal disputes.
Yeah.
This would have been a nightmare of epic proportions for this HOA. They didn't have a darn choice, and I knew they didn't have a choice. They should have been a lot more careful, especially this obnoxious board president who had 3 violations versus my client's 1 violation. So, needless to say, my client got the variance. My client's greenhouse is in good health, okay? All that was required, and we agreed to this because we're reasonable, was he had to plant 3 trees, 3 little trees that would, when they were grown, and he got 8 months to have them grown, when they were grown, they would block view of one little part of the greenhouse from the neighbor's property. And the neighbor hadn't even complained, but they didn't want to deal with a future complaint. So the HOA said, plant these 3 trees, and once they're mature, they'll block any view. Okay? So no problem. We'll do that. 3 little trees. No biggie. It was done within 2 days. Okay? And don't go around telling everybody about it. We refused that one. We didn't agree to that. We will not agree to confidentiality in writing, but we will tell you we don't have plans of doing that. So they didn't insist on that. We waived attorney's fees. We said, we won't insist that you pay us back. We'll let you slide, but that fine has to be returned. And you must return, it's now been, 6 months since end of construction. You haven't returned his deposit yet. Remember that management deposit that goes to the HOA? Yeah. You haven't returned it yet. That needs to be returned within, 2 weeks of signing the variance and the settlement. We got that done.
Fantastic.
My client, very happy result.
Yeah.
I then met with a series of other homeowners from the same community at this client's house on a Sunday. We had a nice little barbecue I was invited to. I did a free consultation with like 8 other people, and a couple of them hired us as well for the board.
Nice.
Very similar things, and I was able to get all those addressed very quickly. Now, I will say, I do want to do a shout out without naming names. Although this law firm isn't one of my favorites, the lawyer in particular that was working at the law firm for the other side, actually I have a good deal of respect for this lawyer. He has always been a straight shooter. He does not play those infantile, asinine games that a lot of HOA side lawyers play. I know you were one of the ones that didn't. So is this person. So I'm not going to name his name, but he'll recognize this story if he watches the podcast, and he's aware of the podcast, and he'll know who I'm talking about. And so thank you to you, because you're actually a mensch. Okay.
And I'll echo your
and you know who
sentiments,
it is,
because I've had the same degree of.
We deal with that lawyer and
professionalism
everybody at that law firm in a lot of our cases, because that's one of the top California law firms that represent HOAs. And that law firm has had some really, really crappy attorneys, but he's one of the good ones. And it's always a pleasure to have him, because now you're dealing with a professional, and you can really negotiate and deal with people if everybody is reasonable and not crazy. But he also has client control. When he has a crazy client, this person has the ability to say, look, I get what you're saying, but that's not going to wash. You're going to get creamed. And he did that with this board, because I promise you, this board president was going bananas, because how dare somebody challenge me and win against me? That will not happen. Well, it happened. He controlled this maniac. Okay? And she gets to keep her stuff too, because of course she's not disciplining herself. And my client's not demanding that all of them get pulled down. That was never his goal. He doesn't really care. He just wanted his greenhouse.
That's a phenomenal result for your client.
Yeah.
Really well done.
Yeah. So we got it. Great. No problem. Bottom line, before I shut things down on this, is there anything you want to add about selective enforcement? Anything you want to, Sam, that you wanted to talk about?
I think we covered pretty well. The only comment, and I think we kind of in passing alluded to this, is if you happen to know friends, neighbors, people you're kind of friendly with, you can ask them like, hey, are they giving you the same type of treatment? What's happening in your case? Have you submitted an application? Because oftentimes it's difficult in a pre-lawsuit posture to get a lot of those details.
That's right.
And especially when bad boards do not volunteer it or cooperate. So you can easily talk to your neighbors and kind of engage them.
Don't be afraid to go and ask people.
Yeah.
Say, hey, I love that paint color.
Yeah.
I just went and applied, and they said no. Did they tell you that you couldn't have it, or did you just, or are they going after you, or did you put it up on your own? Like, what's going on?
That's right.
Don't characterize it so that they think you're attacking them, because you're not. Actually, you're not. What you're, and it's not even like, well, if he's got it, I want it. It's not like you're saying, if he's got it, I want it. You are saying that. What you're not saying is, if I can't have it, make him take it down. You're not saying that.
You're reconfirming your suspicion, essentially.
That's right.
And then you can kind of endeavor.
But you aren't demanding the HOA go after them. You're actually saying, give me a variance. HOAs can give variances, folks.
That's right.
Okay? Anyway, listen, selective enforcement, illegal. Often easy to spot. If you find yourself in that scenario, just like Sam was described, pick up some evidence, talk to your neighbors, get some documents. Layer, if your due process rights and the same issue are also violated, start layering your different attacks together and go in as one argument so that you can apply a lot more leverage against your HOA. If you like this episode, please hit the like button. If you haven't already done so, please subscribe to our channel, HOA Hell. If you have any questions or comments, or you want to tell us a story about your experience in your HOA, we'd love to hear from you. Until next time, have a wonderful day.